Welcome to today's workshop on impact of the Foreign Exchange Management Act 1999 on insolvency resolution under the Insolvency and Bankruptcy Code 2016. As you know, in an increasingly globalized economy, Indian corporate debtors are deeply integrated with cross-border transactions involving foreign investments, external commercial borrowings, overseas subsidies and joint ventures, phone bank accounts, and international trade settlements. Consequently, insolvency proceedings under the IBC are now frequently intersecting with regulatory compliance and enforcement issues under FEMA. The IBC is a comprehensive economic legislation aimed at time-bound insolvency resolution, maximization of value of assets, and balancing the interests of creditors and other stakeholders. In contrast, the Foreign Exchange Management Act 1999 is a regulatory statute enacted to facilitate external trade and payments, regulate foreign exchange transactions, and ensure more economic stability and enforcement primarily through the RBI and the ED. During CIRP process, the interim resolution professional and resolution professional assume control over the corporate debtor, preserve and manage assets, and examine historical transactions. At the same time, issues such as unauthorized foreign remittance, violation of FDA and ECB norms, delayed or non-reporting under FEMA, overseas diversion of funds, and pending education or compounding proceedings often practically we face such type of challenges. The parallel developments raise critical questions regarding the extent of moratorium, requirement of regulatory approvals, treatment of foreign assets, and continuity of FEMA proceeding during CRP. The judiciary has repeatedly emphasized that the IBC is a special legislation. As you know, with overriding effect in matters of insolvency, while FEMA remains a regulatory law governing foreign exchange transaction, as in the leading so many cases, we will also discuss so many leading cases related to on this topic. For just say in Civis Ribbon Private Limited versus Union of India, the Supreme Court recognized the IBC is an economic legislation with the primary objective of resolution and revival of the corporate debtor. Similarly, in Committee of Creditors of SR Steel India Limited, Satish versus Kumar Gupta, the court underscored the primacy of value maximization and commercial wisdom during insolvency resolution. Specific to the interface between insolvency proceedings and regulatory statute, courts have adopted a harmonious construction approach in JSW Steel Limited versus Mahindra case and related NCLT decisions. It has been clarified that regulatory actions cannot be allowed to derail or defeat the insolvency resolution process, particularly where the assets from part of the insolvency or liquidation state. Although there are so many ruling errors in the context of the regulatory laws, the principle equally guide the treatment of FEMA related proceeding during CRP. Further, Supreme Court in Manish Kumar versus Union of India upheld that the constitutional validity of Section 32A of the IBC reinforcing the clean state principle, where the corporate debtor and its assets are insulated from past liabilities upon approval of resolution plan. Courts have also consistently observed that while IBC cannot be used as a shield to legitimize illegal foreign exchange transactions, FEMA proceeding must be conducted in a manner that doesn't frustrate the timelines objective and revival centric framework of the IBC. The emphasis remains on regulatory compliances without underlying insolvency resolution process. We will cover in this session the legal framework, the role and responsibility of IRP, RP, identification of foreign exchange, treatment of foreign assets, impact of FEMA violation. By the end of this workshop, participant we will gain a clear and practical perspective on navigating FEMA related challenges during insolvency resolution process. Now, in this session, we will cover first, we will discuss PAMBL, overview of FEMA and IBC legal framework. Is this visible to everyone? Na? Is PPT is moving? Na?
Yeah, it is visible.
Okay, okay. Now, also moving.
Yes.
Okay, okay. Now let's start. First, we will discuss index. What means what are the things we will cover in this? First, we will discuss on preamble, overview of FEMA and IBC legal framework, interplay between FEMA and IBC, moratorium under IBC versus FEMA proceedings. As we know, as of now, government has not notified cross-border insolvency resolution process and also group insolvency resolution process uh, has yet to notified by the government of India. What is the role of IRP-RP, liquidator under FEMA regime, process of reporting and regulation of FEMA violations, practical challenges which we have to face, and what are the criticisms in FEMA companies compliance during CRP, impact of FEMA on CRP, resolution applications and value maximization, what impact on resolution applicants and stakeholders, FEMA perspective, landmark judgments and regulatory clarifications on FEMA and IBC, landmark judicial pronouncements and regulatory clarifications involving the interplay between FEMA and the Insolvency and Bankruptcy Code. In last, we will discuss the means advanced and critical type of FOQs on FEMA proceedings under IBC 2016. Let's start with preamble. First, we will understand preamble. In preamble, we will cover objective of the workshop, relevance of FEMA compliance in cross-border insolvency and foreign transactions, growing interface between insolvency law and foreign exchange regulations. Because when company is having assets outside India, then FEMA will come into the picture. Because in the liquidation process, we are also to have to sold the means outside assets. So then we will have to take the approval from RBI. In this perspective, we will cover what are the objective, what are the relevance, what are the growing interface between insolvency law and foreign exchange. Currently, presently, we have to face more challenges because we don't have the clarity on the cross border resolution insolvency process, because government is yet to notified the means sections related to the cross border and group insolvency process that is pending at the end of the government. Preamble. The IBC, as we know, Act enacted to provide a comprehensive time-bound framework for the resolution of insolvency, and its objective is maximization of value of assets and promotion of entrepreneurship and creditability. In practice, insolvency resolution increasingly involves in titles with foreign investment, overseas assets, external commercial borrowings, cross-border guarantees, and non-resident stakeholders, thereby bringing the Foreign Exchange Management Act and the regulations made there the under into sharp focuses. FEMA governs all cross-border capital and current account transaction in India and prescribes strict regulatory compliance relating to the foreign investment debt. In this, we cover foreign investment, debt restructuring, share transfer, pricing guidelines, sectoral caps, and under the FEMA, there is a sectoral caps. How many means limit is given? How many means, for example, if for any foreign entity or NRI can want to invest in India, so there is a sectoral cap is also means prescribed in the FEMA Act. And repatriation of the funds during the CRP and liquidation under IBC, Resolution Professional Committee of Creditor and resolution applicants often face significant challenges in aligning the commercial objectives of the resolution with FEMA compliances. Because as an insolvency professional, resolution professional, we have to complete the resolution process within a time frame. When FEMA came into the picture, there may be chance there may be chance we have to take the extensions, because in some of the cases we have to take the approval from the RBI. In that cases, we can take extension because as we know we have to complete the insolvency resolution process in 1 days, but we can take extension in case if we have to take approval from FEMA and time is taking more than normally, so then we can take extension in that case. The intersection of FEMA and IBC raises critical legal questions, particularly concerning regulatory approvals, treatment of foreign creditors and investor implementation of resolution plans, and the extent to which the non-obstain clause under Section 238 of the IBC can override FEMA provisions. This is just like PMLA. Prevention means IBC will override the FEMA, but FEMA is also a civil nature. So that's why, in case if any resolution means applicant submit the resolution plan, in case if there is a FEMA related issues are there, so then we can go for a compounding the penalties. And if and we can also means mention in the resolution plan, in case if there is a chance कि there is a penalty and we know कि something can be asked by the government, so then we can mention in the resolution plan. The workshop and Section 238 of the IBC can override FEMA provisions. Judicially pronouncements and regulatory clarifications have attempted to address these issues, yet practical ambiguities can continue to persist. The workshop aims to provide a structured understanding of the impact of FEMA on insolvency resolution under the IBC through an examination of statutory provisions, regulatory framework, and involving jurisprudence. When we face any challenge related to FEMA, there are leading judgment cases are there, means on the related matter, which was given by the Honorable Supreme Court and CLAT and NCLT. Then we have to refer these landmark judgment cases to resolve these type of challenges practically. The objective of the workshop to on impact on FEMA on resolution under IBC 2016 are to provide a clear understanding on the applicability of FEMA and its regulation during CRP and liquidation proceedings under the IBC. And as key FEMA related issues in insolvency, including foreign direct investment, external commercial borrowing is there, overseas guarantee, share transfer involving non-resident pricing guidelines, sectoral caps, and reputation of funds. Examine the interplay between FEMA and IBC, particularly the scope and limitations of the overriding effect, because there is overriding effect as per Section 238 of the IBC versus FEMA. Discuss landmark judicial pronouncements and regulatory guidance impacting FEMA compliance in resolution process. Equip insolvency professional, legal practitioners, lenders, and resolution applicants with practical insight and compliance strategy to facilitate effectively and timely implementation of resolution plans. Identify practical challenges, regulatory bottlenecks, and gray areas, and encourage informed discussion on the need of harmonization between insolvency law and foreign exchange regulations. Relevance of FEMA compliance in cross-border insolvency and foreign transactions. Contest cross-border insolvency and FEMA interface with increasing foreign direct investment, external commercial borrowing, because normally in every company, most of the companies take you will find there is a FDI investment is there, external commercial borrowing is there, cross-border guarantees is there. Because if any company is having their subsidiary in outside India, so then when company will go into the resolution process, then we will have to deal the outside means assets. So then when we will deal outside assets, liabilities, so then FIMA will come into the picture. So that's why the IBC frequently involves foreign creditors, non-resident shareholders, and international resolution applications. While the IBC seeks to ensure speedy and value maximization resolution, FEMA regulate how capital enters, exists, or restructured in India. Means when company is in the resolution process as a insolvency professional, our main objective is to resolve, means complete the resolution process within a time frame period. But if if company related assets is also outside India, and company is already taken the FDI, or there is a external commercial borrowing, so then we will have to means take the approval from the RBI. So there may be chance of taking means time, we will not be able to complete the resolution process within time frame period. So then we can approach to the adjudicating authority and take extension in case if time is taken in this process of the approval from RBI, in case of to sell the assets which are outside India. So then accordingly we have to means manage this matters when FEMA is there. Unlike IBC, FEMA is not a merely procedural but a sovereign regulatory statute governing foreign exchange aimed at protecting macroeconomic stability. Therefore, compliance with FEMA becomes unavoidable even during insolvency proceedings. Okay, now key area where FEMA becomes relevant in insolvency resolution. Foreign direct investment and share transfer. During CRP resolution plans often involve transfer of shares from resident to non-resident or vice versa. Fresh issuance of shares to foreign resolution applicants. If there is a foreign resolution applicant, so then we will have to issue the shares. So then these our activity will attract the approval from the FEMA. Conversion of foreign debt into equity. Such transaction must comply with sectoral caps. There is a sectoral cap. If any means NRI want to do any investment in India, so there is a sectoral cap in insurance. For example, I'm giving you example. If there is a sector insurance, so then NRI can invest up to 49%. Means sectoral cap is there according to the industry to industry. Maximum amount can be invested as per sectoral caps, which is prescribed under the FEMA Act. Anti-route. There are anti-route automatic and approval. In automatic route, is there and approval when we have to take the approval from the government. Pricing guidelines is also prescribed in the FEMA. Reporting requirements, FCGP and FCTS, when we are getting any means for remittance. For example, when you are going to issue share share to the outside company or outside person, so then foreign investment will come. So then we have to submit the FCGP and FCTRS with the authorized dealer. Authorized dealer means if company is having the HDFC Bank, so then we will submit these reporting documents with our means HDFC Bank, and HDFC Bank will report to the RBI. So means these reporting documents are to submit with the authorized dealer, means authorized bank. Ultimately, we are in this in we can understand we are reporting to the RBI through our bank. Non-compliance can render the resolution plan unimplementable even if approved by the COC and NCLAT. And another is in case of external commercial borrowing and foreign debt restructuring is there, then foreign lenders may be part of the COC or claimants. Resolution plan may propose haircuts to ECB lenders, conversion of ECB, a standard commercial borrowing if we have taken, so then we can convert into the equity because we want to do the we means as a resolution professional, we are to settle. So then in that case, if there is we have taken the external commercial borrowing, so if in case if need, so we have to sometime do the conversion of ECB to equity shares, rescheduling of right of foreign debt. All such actions require RBI compliance and approval, as ECB are strictly regulated under FEMA. Another one is repatriation of sale proceeds and exit of foreign investor. Resolution may involve exit of foreign shareholders, sale of assets to foreign buyers, distribution of proceeds to non-resident creditors. FEMA governs repatriation limits, mode of payment, withholding tax interplay, and use restrictions. Another is overseas assets and guarantees. If corporate debtors may have subsidies abroad, foreign bank accounts are outside, granted issues to foreign lenders, realization or enforcement of such assets must comply with the FEMA and host country laws. FEMA versus IBC. Does IBC override FEMA? As per section 238 of IBC provides overriding effect over inconsistent laws. However, courts have consistently held that IBC doesn't automatically override FEMA, as FEMA is a regulatory law, not a recovery or enforcement statute. What is the principle established in this situation? IBC overrides procedural and recovery laws, but regulatory compliance and under FEMA must still be fulfilled unless expressly exempted. For example, if companies in CRP process, And if we are doing any activity which covered under the FEMA, if there is a reporting part is there, then we will have to do the reporting. No doubt IBC will override the FEMA, but regulatory compliance will have to done by the company or the means insolvency resolution professional. And we will understand with the help of the landmark judgment cases. There is a case Embassy Property Development Private Limited versus State of Karnataka. Supreme Court held that NCLT cannot compel statutory authorities to grant approvals. Regulatory permissions, including under FEMA, cannot be bypassed by insolvency proceedings. This, if company is insolvency professional resolution process, it doesn't mean ki means we will bypass the FEMA Act. If there is a requirement, we have to take approval for RBI, so then we will have to take the approval from RBI. So it doesn't mean कि company is in resolution process and we will bypass the FEMA Act. And what is the relevance? IBC resolutions involving foreign jurisdiction must align with FEMA and domestic public policy. There was another case, Vodafone International Holding, BV versus Union of India. Supreme Court recognized that cross-border share transfer have FEMA implications. Regulatory compliance cannot be ignored merely because transaction occurs outside India. Okay, because if any company is in solvency resolution process or in liquidation process, when we are dealing with FEMA, when we will deal within FEMA, when, if, for example, if we are to transfer the shares, so then we will have to take the approval from the FEMA. We cannot bypass the RBI or FEMA Act. Relevance in insolvency cases involving offshore holding structures, FEMA scrutiny remains critical. There was another case, Jet Airways India Limited versus Anclade 2019, recognized cross-border insolvency coordination. Actually, practically, currently we are facing little bit challenges in the absence of the cross-border insolvency means related sections are not there, and when we have to deal the group insolvency resolution in the case of Videocon, so we didn't have the specific means sections to deal these type of matters. In this case, we will have to do or manage as per the until the means till the time government notified means sections related to cross-border group insolvency, so then we will have to deal as per the means prescribed or suggested or guided by the educating authority. Because there are landmark cases also already means we have. So in the light of the landmark judgment cases, we are to solve these and face and manage these type of situations. Now, in case of Jet Airways, recognize cross-border insolvency coordination, emphasize compliance with Indian laws, including FEMA, while dealing with foreign proceedings. What was the relevance? IBC resolutions involving foreign jurisdiction must align with FEMA and domestic public policy. There was another case, Binani Industries Limited versus Bank of Baroda, held that resolution must be fair, equitable, and compliant with the law. When we are saying compliant with the law, so it will also cover the FEMA. Resolution plans violating statute provisions are not sustainable. So means when we are means COC is approving the resolution plan, so it and means then educating authority will also approve the resolution plan. But resolution plan must be as per the statute provisions and compliant with the prevailing laws. Even FEMA non-compliance can invalidate a resolution plan despite COC approval. Means if there is a non-compliance is there, if in case COC approves, so then educating authority will not approve the resolution plan. In any how case, resolution plan must be compliance with the laws. So this is very important and critical and means important judgment given in this case. Means if there is a known compliance is there, even if COC approve the plan, then adjudicate authority will definitely reject that plan in case if there is a known compliance is there. And there is another case, ArcelorMittal India Private Limited versus Tish Kumar Gupta. So in this case, judgment given by the Honorable Supreme Court emphasized that the resolution plan must be legally implementable. Okay, if resolution plan is not legal, if something is means as per law, if there is a irregularity is there, so then that plan will not be implementable. Compliance with all applicable laws is mandatory. Means when that plan will be illegal, not legal, when there is a non-compliance is there. If there is a non-compliance, it means that compliance in the means absence of the means compliant, so then that resolution plan can be rejected by the adjudicating authority. FEMA compliance is a part of the applicable law. Okay, under section 32E of IBC. There was another case, Eduless Assets Reconstruction Company versus GTL Infrastructure Limited, NCLAT 2018. Resolution plan cannot seek blanket waivers from statutory compliance. Okay, means if whenever any resolution plan is approved by the COC, it will not be blanket waivers. Means it doesn't mean कि if company is in a resolution process, so then there is no then there is no need to means see other compliances, because we as per IBC code we have the overriding fact that it doesn't mean कि we will not comply the other laws, prevailing laws. We will have to means follow the existing or means prevailing laws. Otherwise, resolution plan can be rejected by the adjudicating authority. Relevance, FEMA violations cannot be cured merely by NCLT approval. Okay, means if there is a violation is there, it doesn't mean कि company is in insolvency process and the company have the edge or benefit to violate any act or any laws, including FEMA. Regulatory position of RBI. RBI has clarified that IBC doesn't grant automatic FEMA exemptions. Okay. So that is very, very important. Regulatory position of RBI. RBI has clarified that IBC doesn't grant automatic FEMA exemption. And if any company is in resolution process, company will have to follow the compliance as per the FEMA. Company didn't have or doesn't have the FEMA exemptions. If we cannot assume if company is in insolvency process, so then we will not there is no need to means report or follow or comply the FEMA Act. It doesn't means. RBI has clear cut clarified that IBC doesn't grant automatic FEMA exemptions. Post approval of resolution plan, necessary FEMA approvals must be obtained. If in case if resolution plan is there and in resolution plan it's mentioned that we will take external commercial borrowing or we will issue share to outside party, so then as per resolution plan, after implementing the resolution plan, further FEMA approval will be taken to comply the FEMA Act. In certain cases, RBI has adopted a pragmatic approach to facilitate resolution plan, but compliance remains mandatory. Compliance means if there is a requirement for reporting, for example, FCGPR, FCTRS, as we have to submit the reporting with the RBI through authorized dealer. Who is the authorized dealer? My mediocre bank will be the authorized dealer, because we don't means when we are getting funds, when we are submitting FCGPR, so then we have to submit with the authorized dealer. We directly don't miss submit these documents with directly with RBI. We submit all these documents with the through the authorized dealer. In which bank we received the funds? Okay, that bank will be the authorized dealer for us. What are the practical challenges in FEMA IBC interface? Delays in RBI approvals affecting CRP timelines. So, because sometimes it takes time to get the approval of RBI. In that case, what will happen? Because as per insolvency resolution process, we need to complete the resolution process within a time bound period with maximization of value of the assets. But it doesn't mean if we are to take the RBI approval, we will bypass. No, we will take approval. In that case, we will approach to the adjudicating authority and will seek for extension. Okay, so in this case, we will have to take the means extension from the adjudicating authority. Uncertainty on pricing norms during distressed sales. ECB restructuring complexity is there. Absence of a comprehensive cross-border insolvency framework in IBC. Part Z, Part Z yet to be notified. Because as we have already discussed, right now we don't have means means specific guidelines how to deal the cross-border insolvency framework. We don't have, and government is to notify. That's why we are little bit facing means challenge, but already we have the cases on the cross-border insolvency framework, and there is also there is a landmark judgment is also there. In case we have to face is any challenge, then we refer these means judgments and judgments to tackle these type of situations until we get the notification from the government side. Now, conclusion. FEMA compliance play a decisive role in cross-border insolvency resolution process under the IBC. While the IBC aims at value maximization and speedy resolution. So there is a difference because FEMA compliance plays a decisive role in cross-border insolvency resolution process, but IBC objective is different. IBC objective is to resolve the resolution process. This is a speedy resolution with value maximization of the assets. But FEMA is focused on the compliance part. When any company or any person is dealing with out of India, and there is an investment and there is a loan, so in that case we have to take the approval from the RBI, and there is a automatic route also there, and there is a government route. And if in case if we are going for government route, in some of the cases we are to go for a means automatic route, and they when there is no specific for automatic route, then we have to take the first approval from the government. So that is the government route. Now, FEMA ensures regulatory discipline in foreign exchange transactions. Court have consistently maintained a balanced approach, holding that insolvency resolution cannot be used as a tool to circumvent sovereign regulatory frameworks for successful implementation of resolution plans involving foreign elements. Early identification of FEMA issues. Okay, whenever we are means dealing with the resolution plan, so if we are well in advance, we are identifying what will be the FEMA issues. So if there is a proactive approach is there, so then we can manage or tackle these type of means activities or situations smoothly within a less time. FEMA issues, proactive engagement with RBI, and legally compliant structuring of transactions are indispensable. So that is the conclusion. Now, next point is growing interface between insolvency law and foreign exchange regulations. As you know, the enactment of the IBC code marked a paradigm shift in India's insolvency regime by introducing a time-bound criteria driven. Earlier than IBC, that was not a criteria driven, that was a data driven. Earlier there was a means act SICA. Okay, so means uh, before implementing IBC code by the government of India, the focus was and not driven, means kiter driven, that was a data driven. So that was data driven. Now paradigm shift when after implementing the insolvency bankruptcy code. Now uh, there are three or four. There are four means main points. It will be time bound. It will be kiter driven, and main objective is to maximize the value of the assets. Simultaneously, India's progressive integration with the global economy has resulted in increased foreign investment, cross-border lending, and multinational corporate structures. Due to this, in India, FEMA will attract. When we will deal with foreign investment, cross-border lending, and multinational corporate dealing, in that case, FEMA will, it means come into the picture. This economic realities has led to the growing intersection between insolvency law and the foreign exchange regulatory framework governed by the FEMA Management Act, which is supervised या managed or handled by the RBI. As insolvency proceedings increasingly involve foreign creditor, non-resident shareholder, overseas assets, and international resolution applications, compliance with FEMA and regulations issued by the RBI has become an integral component of insolvency resolution under IBC. As insolvency proceedings increasingly, because now day by day we are seeing insolvency proceedings are means increasingly. When insolvency proceeding will are increasingly, so then there are so many companies which already have foreign creditors, non resident shareholders, or overseas assets, and international resolution applicants, and compliance is already there. Uh, or when any resolution plan is submitted, so then maybe there may be in as per resolution plan, we will have to means deal with the foreign creditors, or we will have to issue the means equity to the external commercial borrowings. So then FEMA will come into the picture. So then we will have to do the compliance means for FEMA under means as alignment with the IBC code, because when we are in the insolvency resolution process, we are also to submit the relevant means and also to do the reporting with as per Companies Act. In the same manner, when we are dealing with the means investment, foreign investment, or loan, so then we will have to do the comply the compliance as per FEMA, and we will have to also do the reporting as per FEMA. Okay, and we cannot bypass the means any reporting part of FEMA because that company, particular company, is in the resolution process. Okay, so that is not, my company doesn't have that type of edge. What are the statutory framework governing the interface? Insolvency Bankruptcy Code, Section 32(2)(e), resolution plan must comply with applicable laws. When we are discussing with applicable laws also include FEMA. Whatever applicable laws are there, we will have to comply, whether resolution plan approved by the COC. In the absence of the applicable, if you are not complying with the applicable laws, if any resolution plan is approved by the COC, that will reject by the adjudicating authority. That is the mandatory part. In case of any resolution plan, must be comply with the applicable laws. And there is also another section, important section, as per the IBC code. The section is 238, overriding effect of IBC over inconsistent laws. Okay, we very well know we know that there is a overriding effect of the IBC when there is inconsistency with in the laws. So that section is very important for us as the insolvency resolution process, but it it doesn't mean that we will not comply other laws. Okay. In case if there is an inconsistency is there, so then definitely IBC will override the have the overriding effect, but we will have to comply the other applicable laws during the CIRP and also after the means when resolution plan is approved, then resolution applicant will also means comply the applicable laws, but resolution applicant will have the clean state. Whatever the previous things done, that will not be means burden for the resolution applicant. He will have the clean state, right? Part 3 and proposed part Z. Cross-border insolvency framework yet to be notified. These are the most important three things. Okay, means with all applicable laws covering FEMA also, overriding effect is also in case of inconsistent, but it doesn't mean we will not comply and we will not do further reporting. Even if the company is in the insolvency resolution process. And third one is most important. Currently, practically, we have to face challenges due to the means absence of the cross-border insolvency framework, uh, because we don't have this specific section and specific guidelines how to deal cross-border insolvency. So that's why practically we have to face more challenges other than on which already government already notified the sections. The another is Foreign Exchange Management Act 1999 regulates capital and current account transactions, governs FDI, ECB, foreign guarantees, repatriation and overseas investment enforced through RBI regulations and circulars. On time to time, RBI circulate means notified in case of any change in regulations. The interaction between the statutes raise the question of whether the commercial objective of IBC can override sovereign regulatory controls under FEMA. What are the key areas of interface? Okay, foreign investment in resolution plan. Means key areas of interface when it will be interfaced. Foreign investment in resolution plan. Resolution plan may involve acquisition of such companies by foreign resolution applicants. Another issue or transfer of shares to non-residents. Okay, when we are issuing transfer or shares to non-resident persons, so then definitely FEMA will attract. Okay, so then we'll have to do the compliance means related to the FEMA. Conversion of foreign debt into equity. If already company have the debt and as per resolution plan, company will convert that debt into the equity because they want to do means reduce the liability in the form of the debt. So then if as per resolution plan, if there is need or as per resolution plan con, to convert foreign debt into equity, these section must comply with FEMA norms relating to the anti-routes and sectoral caps. That these things will be happened. These things, just a 1 minute. These things will be happened subject to anti-routes, sectoral caps. Means if there is a sectoral caps already given by as per the industry, up in this industry maximum invest can be done by up to that percentage. So there is a sectoral cap is also there. Anti-routes means automatic route or government routes. Okay, pricing guidelines is also there. Okay, on how on what basis you will decide the pricing when we are going to issue shares. Okay, it's already specified in the FEMA Act reporting guidelines. So these all the things are already defined and prescribed under the FEMA Act. When we will deal in these things, so that will be subject to the means these compliance. When acquisition of such companies by foreign resolution applicants, when we are issue or transferring shares to non-resident person, when converting of foreign debt into equity, subject to what are the anti-routes already prescribed or mentioned in the FEMA, what how many percentage or sectoral caps already prescribed in the FEMA, and also pricing guidelines, also how to means set what will be the price for these type of transactions already cited in the FEMA. What will be the reporting guidelines? Means because when there is a standard reporting is there. When, for example, if we are getting funds, so then we will have to submit the FCGPR1, FCTRS within 30 days, within 60 days. Already everything is prescribed in the FEMA Act on the reporting requirement, subject to what type of transactions. So then we have to refer the FEMA Act, and we will have to do the compliance as per the FEMA Act. The another area comes external commercial borrowings and foreign creditors are there. Foreign lenders frequently form part of the committee of creditors. If there is a foreign lender is there, so that will be the part of the COC. Resolution plan often proposes haircut or write-offs of ECB, restructuring or conversion of foreign debt. Such restructuring requires compliance with FEMA ECB regulations and in many cases RBI approval. Because when we are in the resolution process, we have to do the structural change, means reduce the liability in the interest of the company as per the business requirement, because our intention is to survive the business, revive the business within time frame period. So that's so in this situation, how company can survive if company is having more debt, so then company will have to pay the interest. So in that case, company, if company is earning is less and means and in liability is more, and due to this we have to pay the interest, then company will not be able to survive. In that case, what is the means best scenario? If we can convert that debt into the equity, so means there are so many situations we have to deal. But when we will deal this type of transaction, this type of situation, then FEMA will attract and we will have to do the compliance as per the FEMA. And when we are dealing with the external commercial borrowing, there are specific ECB regulations are there. We will have to follow the compliance and the requirement as per the FEMA Act, and also reporting as per the FEMA Act. And in many cases, we have to take approval from the RBI when we are dealing with the external commercial borrowing. Repatriation of funds and exit of non-resident. If situation comes, resolution or liquidation may require repatriation of sale proceeds to non-resident creditors or investor. Exit of foreign shareholders. FEMA governs the manner, limits, and condition of such repatriation. Okay. Now, another situation, overseas assets and cross-border structures. Corporate debtors may have foreign subsidiaries, overseas bank accounts. If we have overseas bank accounts, if we have a subsidiary holding company is in India and we have a subsidiary company in outside India, and we also have bank accounts, overseas bank accounts, assets and guarantees outside India. The monetization or enforcement must comply with the FEMA or foreign judicial laws. Now, IBC override versus FEMA compliance. While Section 238, which we have already discussed, of the IBC provides an overriding effect, courts have consistently held that IBC doesn't grant a blanket override over FEMA, which is a regulatory statute rooted in a public policy. Judicial principle, IBC override recovery oriented or procedural laws, but regulatory compliance under FEMA continue to apply unless specific exemption. Means we already about discussed. Again, we are discussing while Section 238 says there will be override effect. Override means when there is inconsistency consistent with any other law, so then IBC will override. But it doesn't mean we will not comply all other prevailing laws. We will have to follow, also comply the prevailing existing laws. Otherwise, our resolution plan will not be legal and may or will be rejected by the adjudicating authority, and that will not be also as per the IBC code 2016, because IBC also says overriding effect will be there, but other the other means compliance for other existing or prevailing law is must. 238 IBC provides an overriding effect. Courts have consistently held that IBC doesn't grant a blanket override over FEMA, which is regulatory statute rooted in a public policy. Judicial principle: IBC overrides recovery oriented or procedural laws. But regulatory compliance means IBC will override recovery oriented, because if there are assets in, say, for example, in under the PMLA, so then regulation professional will take that assets in their custody, but or means recovery oriented or procedural law. Okay, but regulatory compliance. But if there is a reporting part is there, if there is a compliance, so that will be done by the resolution professional, or after implementing the resolution plan, the resolution applicant will also do the regulatory compliance under FEMA, continue to apply unless if unless until if there is any means exemption is there. Okay. Now we will see the related landmark judgment cases related on that part. Embassy Property Developments Private Limited versus State Karnataka. NCLT cannot compel statutory authorities to grant approval. Okay, means NCLT will not compel any statutory authority, means to RBI, to grant approval, blanket approval, that entity or that company is not required to do the compliance. So that will not be given by the adjudicating authority. Means NCLT cannot compel statutory authorities to grant approval. Regulatory permissions cannot be bypassed. Wherever we required regulatory permissions, which that regulatory permissions will be definitely taken also during the insolvency proceedings, like another normal company which company is doing business in India, they are also taking regulatory permissions. Okay, in the same manner, if any company is in resolution process, that company will also take regulatory permission and will not allowed to bypass insolvency proceedings. Relevance: FEMA approves remain mandate despite NCLT approval or resolution plans. There is another case as Arsar Mittal India Private Limited versus Seashore Gupta. Supreme Court says, as per Honorable Adjudicating Authority, Supreme Court says resolution plan must be legally compliant and implementable. Compliance with all applicable laws is mandatory. Relevance: FEMA compliance falls within scope of applicable laws under IBC. So that is very important judgment and leading case, and also very important in point of view FEMA. Resolution plan must be legally compliant and implementable. Okay, so that is very okay. Now, compliance with all applicable laws is mandatory. When we are saying compliance with all applicable laws, is also including FEMA. Relevance: FEMA compliance falls within scope of applicable law. Okay. Now, there is another case, Binani Industries Limited versus Bank of Baroda Enclave. Resolution plan must adhere to statutory requirements. Commercial wisdom cannot override legality. Levels: FEMA violation cannot invalidate a resolution plan. There was another case, Jet Airways India Limited. Recognize coordination in cross-border insolvency. Emphasize compliance with Indian laws,
Sir,
including
sir, just
FEMA.
just one thing. I think FEMA violations can invalidate a resolution plan, right?
Yes, yes, yes.
Yeah, yeah. Actually, by mistake, I think you mentioned as cannot validate. So that's
No,
why I
no,
know.
FEMA violation can invalidate a resolution plan.
Right. Thank you.
Uh, I also mentioned can invalidate. Okay, there is another case, Jet Airways. Recognized coordination in cross-border insolvency, emphasized compliance with Indian laws, including FEMA. There is a relevance. Cross-border insolvency must respect foreign exchange regulations. There is another case, Eduless Asset Reconstruction Company Limited, GTL Infrastructure. Blanket waivers from statutory compliance cannot be granted. So that is also very important. Relevance, IBC cannot be used by past FEMA requirements. Okay, means when any company is also in insolvency resolution process, so that that company cannot have any edge or any waiver. That company will have to do all the statutory compliance as per the prevailing existing laws. There is another case, Vodafone International Holding, BV versus Union of India, Supreme Court. Cross-border transactions are subject to regulatory scrutiny. Sovereign control over foreign exchange must be preserved. Relevance offshore insolvency structures still attract FEMA implications. Now, what is the regulatory approach by RBI? RBI has clarified that part is very important. RBI has clarified that IBC doesn't dilute FEMA compliances. Necessary approval under FEMA may be obtained post approval of resolution plans. A facilitative approach is adopted in insolvency cases but without compromising regulatory objectives. So these are very important point. RBI has clarified that IBC doesn't dilute FEMA compliance. Necessary approval under FEMA may be obtained post approval of resolution plan. A facilitative approach is adopted in insolvency cases but without compromising regulatory objectives. Now, what are the challenges and emerging trends? Conflicts between IBC timelines and RBI approval process. Okay, practically we have these type of challenges we have to face. But what is the solution in that case? In solution is this: as we have to complete the resolution means process within 180 days, but we in case when RBI approval is there and it's taking time, so then we can seek extension, and we can ask for extension. So then adjudicating authority will definitely give us extension. So extension can be taken in that case. So that is the solution. Okay. Otherwise, what will happen if RBI is taking time? As per taking time means if as per means FEMA or RBI, they have the right to means approval within 30 days. So then we cannot means we ask ki we need approval within 2 days or 3 days because we are dealing that company is in insolvency process. They will take their own time, but we have the solution. In that case, if we know very well ki it will take time, if there is a requirement of approval of 30 days or 60 days, so accordingly we can go for extension. We can seek extension from the adjudicating authority. Now, the another challenge we have to face, pricing and valuation issued in distressed asset sales. Absence of a comprehensive cross-border insolvency regime, because as of now, no notified specific sections or specific laws on the cross-border insolvency process, increasing judicial emphasis on harmonization rather than override. Now, what is the conclusion? The growing interface between insolvency law and foreign exchange regulations reflects that realities of globalized economy. While the IBC aims to ensure timely and efficient resolution of insolvency, FEMA safeguards microeconomic stability, sovereign regulatory interest, judicial precedents have consistently underscored that insolvency resolution can not be a means to circumvent foreign exchange regulations. A balanced and harmonized approach respecting both insolvency objective and foreign exchange controls is essential for effective and sustainable cross-border insolvency in India. Now, overview of FEMA and IBC legal framework. Object this thing that we have done. Okay, overview of FEMA. So we will an effective. Now, little bit we will discuss on the FEMA part and IBC part. An effective understanding of the interface between insolvency law and foreign exchange regulations require a clear appreciation of the legal architecture, objectives, and institutional mechanism under the FEMA and the IBC. FEMA, what is the objective? What are the scope and regulatory philosophy? Objectives of FEMA. FEMA was enacted to facilitate external trade and payments, promote the ordinary development and maintenance of the foreign exchange market in India, ensure microeconomic stability and regulate capital flows. So that is the objective. That was the objective of the FEMA. FEMA marked a shift from the stringent control-oriented regime of FERA to a management-based facilitative regulatory framework focusing on compliance rather than criminalization. Okay. Now, what is the scope of FEMA? FEMA applies capital account transactions, including for if foreign direct investment is there, external commercial borrowing is there, overseas direct investment is there, guarantee and borrowings in foreign currency. So these are the capital account transactions, which include these type of transactions. There are another type of FEMA applies to current account transactions, subject to reasonable restrictions, resident and non-resident, assets and liability held in India and abroad, all cross-border transactions during insolvency process, such as transfer of shares, debt restructuring and repatriation, fall within FEMA scope. Okay, means these are the capital type of transaction. These are the current account transaction, including all cross-border transactions which are done during the insolvency resolution process. Now, what is the regulatory philosophy of under FEMA? Permission-based regime. Transactions allowed unless specifically prohibited, emphasize on prior approvals, reporting or post-transaction compliance between balance between ease of doing business and regulatory control. FEMA is a sovereign regulatory laws rooted in public policy. Means that is permission-based regime. Transactions are allowed unless specifically prohibited. Some of the transactions are prohibited. If there is no prohibited, so then all the transactions are allowed. And in case if approval is required to take from the RBI, so then emphasize on prior approval, and also reporting is all pre-reporting and post-reporting is also there, and balance between ease of doing business and regulatory control is there. FEMA is a sovereign regulatory law, routine public policy. Okay, so that was about the FEMA. Now IBC we know very well. IBC enacted in 2016, consolidated insolvency and bankruptcy laws. That is main objective to time bound insolvency resolution process, but with maximization value of the asset of the corporate debtor. That is the main objective of the IBC code. Time bound and maximization value of the assets, promote entrepreneurship and availability of credit, balance the interest of all the stakeholders. Because when we are in the resolution process, so then we have to maintain the balance of the all the stakeholders. Stakeholders also including operational character, financial character. We cannot means means we have to means maintain the balance and also to work in the interest of the all the stakeholders. But when resolution plan is approved by the COC and educating authority, so then all the resolution plan is applicable all to all the stakeholders. Resolution is preferred over liquidation with a focus on preserving the corporate debtor as a going concern. Because why resolution is preferred over a liquidation? Because our approach is different. When we are in the resolution process, then our approach is going concern approach. Because in case of going concern approach, the value of the assets will be maximized. Because in case if resolution process is not possible, so then company will go into the liquidation. When company will go into the liquidation, then company will have to sell the assets. When company will sell the assets, that asset may be distressed assets. So then value of the assets will be less as compared to the means value when company was in the means CRP. Because everyone knows कि company is going to close, and then the value of the assets means will be less as compared to the going concern approach, because these approaches are different. Going concern means company will miss run, then value of the assets will be more. When company is going to close, so then our approach is to sell the assets, means to liquidate the assets and distribute all the assets as per the waterfall mechanism as section 53. So then our approach will be different when company is in CRP and when company is in liquidation. The timelines under IBC CRP period 180 days, given extendable up to 330 days including, and that extendable period we can seek in case if any approval or any means statutory due to any statutory requirement, if any approval, if anything taking time, so then we can seek for extension from the adjudicating authority. Strict timelines to prevent value erosion. Miss, the objective of this IBC was to resolve the resolution. Otherwise, what was happening earlier when Sika was there? So then it was taking 2 years, 3 years. And when it will take 2 or 3 years, then what will happen? For example, if any manufacturing company have the machinery, if it's taking 3 years, so if when you and company will go into the liquidation, then after 3 years, when we are going to sell that machinery, the value of the machinery will be drastically very less. Maybe due to so many reasons, maybe that machinery is not in running condition. And another maybe due to the in case there is a technological change, so then what will happen? Then that machinery is not required. So then the value of that assets will be almost zero or very less. So that's why IBC code into the picture. If company is going into the resolution process, it should not take much time. So that's why there is a timeline is there, because if timeline is there, if it's taking 6 months, say, so then what will happen? At least your value of the assets will be on higher side as compared to the Sika. In Sika or before IBC, so they in these cases it was taking very much time. So that's why it's very important to resolve the means issues under the insolvency resolution process timely. If we will resolve the resolution, so then what will happen? The value of the assets also will be on the maximum side. Emphasize on the speed and certainty. Principle of value maximization. Commercial decisions rest with the COC. Okay, so that is also very important. As you know, all the commercial wisdom decisions can only be taken by the COC. Insolvency professional is only a facilitator. For example, if registered value means insolvency resolution IRP or RP will appoint a registered valuer. Registered valuer will submit their means valuation report with RP. RP will go through that report. In case if registered value miss anything, so then he can discuss, and accordingly the registered valuer will do the needful. But registered value will not do the changes. Means RP is saying no. He will have to follow the means standards. As per standard, he will have to submit the report. Then that report will go into the COC. COC will refer that report, and COC is also not bound to take decision on the registered value report. They can refer the resolution plan means that valuation report may help to the COC to taking commercial wisdom decisions. Okay, but they are not bound to take only the decision on the basis of the registered valuation report. Okay, so then it means commercial wisdom decisions can only be taken by the committee of creditors. When the committee of creditors will approve the resolution plan, so then Adjudicating authority will also approve the resolution plan if that resolution plan is compliant with the applicable laws and as per IBC Act. So then adjudicating authority will means approve that resolution plan. They will not go into the resolution plan because they will not interfere the commercial wisdom decision taken by the COC. Value maximization must operate within the framework of applicable laws, including FEMA. Value maximization must operate within the framework of applicable laws, including FEMA. Now, what are the key authorities under FEMA? Primary regulator under FEMA issues rules, regulator, and circulars of an FDI, ECB, ODI, and reputation. Means who is the custodian of all those things? RBI. Okay. RBI is the prime regulator under the FEMA. Okay. Who issues circulars, regulation, rule and regulations on FDI, foreign direct investment, external commercial borrowings, okay, ODA and reputation, grant approvals and post facto regulations, plays a facilitative yet supervisor role. Okay, so these are the key authorities under FEMA, RBI. Under Director of Enforcement, ED. ED investigate contraventions of FEMA. In case of if there is any contraventions, and so then ED will come into the picture. ED will investigate contraventions are there means related to FEMA, conduct search, seizure, and enforcement actions, initiate education proceedings for violations. So that is done by the ED. Now, adjudicating authority under FEMA is appointed by the central government, adjudicate contraventions and impose penalties, exercise quasi-judicial functions. You know, who are the key stakeholders under IBC? As you know, IRP and resolution professional manage the affairs of the corporate data during CIRP, ensure compliance with the applicable laws, examines resolution plans for legal and regulatory compliance, including FEMA. Another stakeholder is COC, comprised with financial characters, exercise commercial wisdom in approving resolution plan, must ensure that the approval plan is legally implementable. When we are talking about the legally implementable means compliant with all the applicable laws. Adjudicating authority means A, NCLT, NCLAT oversees CRP process, approves or reject resolution plans under Section 31, ensure compliance with Section 32, including adherence to applicable laws. Conclusion, while FEMA and IBC pursue different legislative objectives, their legal frameworks intersect significantly in insolvency cases involving foreign elements. FEMA emphasizes regulatory discipline and macroeconomic stability, whereas IBC focuses on timely resolution and value maximization. Effective insolvency resolution in such cases requires a harmonized application of both statutes, ensuring that commercial outcomes under IBC are achieved without compromising FEMA compliance. Means here, without compromising FEMA compliance is here that commercial outcomes. That commercial outcomes under IBC are achieved without compromising FEMA compliances. Okay. Interplay between FEMA and IBC, whether FEMA override IBC or vice versa. Nature of FEMA is a civil regulatory law versus IBC as an economic legislation. Harmonize construction between FEMA and IBC. Applicability of FEMA during CRPL liquidation. Now, interplay between FEMA and IBC. IBC and foreign exchange operate at distinct yet increasingly overlapping legal spheres. While IBC is designed to ensure time-bound resolution process with maximization value of the assets, FEMA is sovereign regulatory statute governing foreign exchange and cross-border capital flows. Okay, so that is covered under the FEMA. The intersection between these two laws raises critical questions of statutory override regulatory compliance and harmonization. Whether FEMA override IBC or vice versa, what are the statutory provisions are given? Section 238 IBC provides that IBC shall have effect notwithstanding anything inconsistent contained in any other law. Section 32E IBC mandates that a resolution plan must comply with all applicable laws. FEMA 1990 doesn't contain a non-obstain clause overriding IBC. Okay. IBC but operates as a public policy based regulatory statute. Judicial positions. Courts have consistently held that IBC doesn't override FEMA in matters of regulatory compliance. Okay, when there is a regulatory compliance, we'll have to follow whether company is in CRP or after implementing the resolution plan. So means courts have consistently held that IBC will override the FEMA where inconsistency is there. But IBC will not override FEMA in matters of the regulatory compliance. So that is very clear cut. Section 238 of IBC applies primarily where there is a direct inconsistency, not where compliance with both statute is possible. So that is important. Okay. Key principle of IBC overrides the procedural and recovery laws, but regulatory statutes like FEMA continue to apply unless explicitly excluded. That is also very important. Landmark judgment, embassy property development, private property. NCLT enclave cannot exercise jurisdiction over matters involving statutory and regulatory approvals. Okay, means when NCLT enclave cannot exercise jurisdiction over matters involving statutory and regulatory if company is to take statutory approval from any statutory body as per the prevailing laws, so then NCLAT or NCLT will not give any blind or any edge to the company. Regulatory compliance cannot be bypassed in insolvency proceedings. This we have already discussed. That is the mandatory. Means if compliance will you have to do whether company is in CRP or liquidation. FEMA approval cannot be waived merely because the resolution plan is approved under the IBC. That is very important. See here. FEMA approval FEMA approval cannot be waived merely because a resolution plan is approved under IBC. Now, coming to the nature of FEMA, as FEMA is a civil regulatory law versus IBC is an economic regulation. Here in IBC, what we are doing? We are helping company to survive or helping or reviving the business. Okay, and FEMA is a civil regulatory because we have to follow the rule and regulations as per FEMA as notified by the RBI. FEMA is civil regulatory law designed to regulate foreign exchange, not to punish. Okay. Emphasize permissions, approval, and compliance. Okay. When we are dealing in foreign exchange, so then as per FEMA, we have to deal. If required, so we will take approval and we will do compliance as per the FEMA, and we will also reporting part is also prescribed. So then we will have to do the reporting as per FEMA. Okay, contraventions result in civil penalties, don't criminal prosecutions. For example, if we have issued shares and we have not reported to authorized dealer within time frame period, okay, so then what will happen? In this case, if there is a contravention is there, so then we will have to pay the penalty. If any contravention is there, as per the FEMA Act, as per the contraventions, we will have to means pay the penalty. But There are civil penalties. We can go and compounding is there. Means we can go and means and pay the penalty, and we can regularize our that means activity if we miss anything. For example, if I'm supposed to submit the FCGPR report within 30 days or 60 days, okay, if I have not reported and I have reported after that period, so then what will happen? Definitely, I can get means notice from the RBI. So in that case, I will have to go and do the compounding. Means I will have to pay the penalty and regularize that transactions. Okay, so means compounding is there. Okay, that is the civil penalty is there, not a criminal prosecution. And in case of IBC, aimed at insolvency resolution, value maximization, and credit discipline, commercial decisions are left to the committee of creditors because they are expert. Because when if they are expert, so they can take well means take good decision because they are mainly in who will be the part of in the committee of guiders, mainly financial guiders, and they can take the commercial wisdom decisions. If if financial guiders are not there, only operational guiders, they will not be able to take commercial wisdom decision. Means who will be the expert? Financial guiders will be the expert as compared to the operational guiders. So that's why commercial decisions are left to the committee of creditors. Focus on speed and certainty. Judicial recognition. Regulatory statutes like FEMA, environmental laws, and mining laws operate independently of IBC. Okay. Now there is a judicial reference. Swiss Ribbons Private Limited versus Union of India recognize that IBC is an economic legislation emphasize balancing of interest and public policies and objectives relevance. While IBC has a primary in insolvency matters, it cannot in nullify regulatory regimes. Means IBC has a primary in insolvency matters. It cannot nullify regulatory means if there is any other law, if reporting is there, compliance is there, so then we will have to do the compliance as per the existing prevailing laws. We can not overrule that applicable laws. Harmonized construction between FEMA and IBC. Doctrine of harmonized construction. Courts adopt harmonized interpretation to give effect to both statutes. Okay. Avoid rendering any provision redundant. Respect resolution intent of both laws. Practical application. Resolution plan may be approved under IBC subject to FEMA compliance. RBI approval may be obtained post approval of resolution plan. NCLT ensures that resolution plan don't violate any applicable laws. Don't violate applicable laws. What are the key provisions? Section 32 to E. IBC acts as the statutory bridge mandating FEMA compliance. There is a landmark case also there. Arthur Mittal, India Private Limited versus Shishwar Gupta Supreme, as per judgment given by the Honorable Supreme Court, resolution plan must be legally implementable. When we are talking about the legally implementable, means that resolution plan must be means compliant as per applicable existing prevailing laws. Compliance with applicable laws is mandatory. Relevance FEMA compliance also integral part to the IBC regulation. When there is a means foreign transactions are there, so then FEMA compliance is also will be the integral part of the IBC regulation. Benigni Industries Limited versus Bank of Baroda and create commercial wisdom decision. Commercial wisdom cannot override the statutory requirement. Okay, means COC approve the resolution plan. Okay, if they approve, they can approve the resolution plan, but it doesn't mean they have the authority to bypass any statutory requirement. If there is a compliance is there, if there is a reporting is there, as per any other means prevailing existing laws, so then that thing will have to means mandatory and that is will have to follow. Means it doesn't mean COC is approving the resolution plan, so they have the right to override any statutory requirement. Okay. So then relevance is there. FEMA, non-compliance can invalidate a resolution plan. Applicability of FEMA during CRP liquidation. During CRP, FEMA applies to issue or transfer of shares to or from non-resident, foreign resolution applications acquiring the corporate debtor, ECB restructuring or conversion, foreign guarantees and overseas assets. What will be the role of RP? Ensure early identification of FEMA issues and coordinate with RBI. So that should be that is the role of the RBI. And during liquidation, FEMA applies to sale of assets to foreign buyers, repatriation of proceeds to non-residents, distribution to foreign creditors, closure of overseas accounts and subsidies. There are also landmark judgment cases are also related to this. Adulus Asset Reconciliation Company Limited versus GTL Infrastructure Limited. Ancillate resolution plan cannot seek blanket waivers from statutory compliance. Relevance FEMA applies throughout CRP regulations. Means resolution plan is not giving blanket waivers from statutory requirement. Okay, and also whether that is CRP, whether that is liquidation. I will also add whether that is the normal business. Okay, FEMA will apply as per the FEMA Act when we are dealing in the foreign exchange related matters. Cross-border insolvency perspective. Recognize there is another landmark Chatham Airways India Limited 2019 and create recognize cross-border insolvency coordination, emphasize compliance with Indian regulatory laws, including FEMA. Okay. Now, what is the conclusion? The interplay between FEMA and IBC reflects a balance between commercial insolvency objective. Okay, means when we are dealing in IBC, that is commercial insolvency with objective, and FEMA is a sovereign regulatory control. Okay, judiciary presidents have firmly established that IBC doesn't provide a carrot balance to bypass FEMA. Instead, courts advocates a harmonized construction where insolvency solution proceeds efficiently under IBC while respecting the regulatory framework under FEMA. For successful insolvency resolution process, foreign elements, early FEMA compliance planning, proactive engagement with RBI, and legally robust resolution structures are indispensable. So next we will discuss on the moratorium under IBC versus FEMA proceedings. We can take 10 to 15 minutes rest if you want. Should we continue? You want to take rest? 10 to 15 minutes?
Sir, will we get a copy of the presentation?
Yes, I will definitely. You will get. I will share.
Sir, we'll take
Yeah,
10
yeah, okay,
minutes
sir.
break, sir.
Yes, sir, we are
Thank you.
good to
Okay.
have a 10,
Okay.
15
Okay. We can take 10 minutes break. Okay.
Yes, 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 please go.
Okay. Okay. Okay, now we can start. Can we start?
Yes.
Okay. Now we will discuss role of IRP, RP and liquidator under FEMA design. Duties of IRP, RP to identify FEMA non-compliances, power and limitations of RP in dealing with RBI or ED, role of liquidator in realization of foreign assets, requirement of RBI approvals during CIRP and liquidation. So that segment is very means important. What will be the role of IRP, RP liquidator under FEMA regime? The insolvency resolution professional framework under the IBC frequently intersects with foreign FEMA where the corporate debtor has foreign investment. Okay. As we have already discussed, when there is a foreign investment, then FEMA will come into the picture. And what will be the role of the IRP, RP liquidator? When corporate debtor has foreign investment, overseas assets, external commercial borrowing, or non-resident stakeholders, in such case, the role of IRP, RP liquidator assume highlighting regulatory significance. Now we will discuss what will be the duty of IRP, RPA to identify FEMA non-compliance. If there is a FEMA non-compliance is there, so then what will be the duty of the IRP? Because naturally we will have to go for compounding. The IRP, RP is under a statutory duty to conduct a thorough examination of the affairs of the corporate debtor and identifying of existing or potential FEMA violation. This includes verification of foreign shareholding, downstream investment and compliance with the sectoral cap and entry routes. Okay, if he will see whether it's okay, foreign shareholding is okay, compliance is there, and also investment as per secretarial cap, which is prescribed as under the FEMA. According to that, is there, and entry route is also means. For example, if there was supposed to take ECB is there was supposed to take external commercial borrowing approval through government. If we have no taken and we take we taken as a means approval route means we will ensure ki whether sectoral cap, in entry routes, and compliance and investment shareholding pattern is as prescribed FEMA or compliances and reporting is also done or not. Verification will be done by the IRP-RP. Examination of external commercial borrowing, foreign currency loans, guarantee and their compliance with RBI regulators is there or not there. Okay, if not there, we will discuss later on. But first, step will be to verify ki whether compliance is there as per rule and regulations, as per FEMA is there or not. Identification of overseas subsidies, joint ventures, bank accounts, and in immovable properties. Review of FEMA reporting compliances. Okay, such as FCGPR, FCTRS, ODA filings, and annual returns have been submitted in the prescribed form. Okay, as per FEMA. Identification of ongoing investigations. If there is an ongoing investigation or education proceedings by RBI or ED, all identified non-compliance or regulatory exposures must be disclosed to the committee of creditors and factored into the resolution strategy. Because if I have identified, so then what happened? I will have to report to COC if there is a non-compliance, so that COC will be able to take appropriate decision and action. Okay. Now, if penalty is there, so then what will happen? If any resolution plan is submitted by the resolution applicant, so then that will be factor. For example, I know कि we will have to go for compounding and we will have to pay the penalty of say 10 crore rupees. And if resolution plan is submitted, so then we will factor that 10 crore rupees in resolution plan. Okay. Otherwise, if we have money, so then we will go for compounding. Otherwise, we'll have to do factor. Okay. So that's why first step will be to identify is there any non-compliance as per FEMA or not. If if we found there is no means there is a compliance is okay, so then no problem. If compliance is not okay, so then we will go for compounding. Okay. Otherwise, we will do the factoring in the resolution plan. Okay, and in reporting part, we will have to see whether FCGP or FCTRS as per number one submitted or not submitted. Then question comes whether submitted on time or not submitted. So if not submitted in time, then that may also attract a penalty, and we will have to go for compounding. So we will have to first verify कि as per FEMA is compliance is there or not there. If not there, so then if there is a time gap is there, what type of violation is there, and what will be the penalty, what will be the means compounding means amount. So accordingly we will have to take action. First we will report to the COC, and accordingly they will take a decision, and we will take action accordingly. Powers and limitations of RP in dealing with RBI ED. RPI must correspond, seek clarification, submit information to RBI or ED regarding the corporate debtor. If if as a RP, if I don't found miss proper document, complete document, so then I can seek clarifications from RBI if RBI or ED. Okay, RB can facilitate applications through regulatory approvals required for implementation of a resolution plan. Okay, if there is a requirement of regulatory approval, so then I will have to take approval. Okay, for the implementation of the resolution plan, the RP may represent the corporate debtor before regulatory authority in relation to the FEMA matters. What are the limitations? The RP cannot seek waiver or relaxation of FEMA provisions solely on the ground of the insolvency that we have already discussed. If there is a compliance part is there, we will have to do the compliance and reporting as per the existing applicable laws. We cannot go for waiver or relaxation, and we cannot override any regulatory or compliance on the basis of that particular company is in the insolvency resolution process. The RP cannot compel RBI or ED to grant approval or stay proceedings. FEMA investigation education continue independently of CRP. Okay, this is just like PMLA. FEMA investigation. They can miss if company is in CRP, so it doesn't mean they don't have the right to investigate. And if there is a personal responsible, if any data is responsible, so for and done intentionally something wrong, so means then education continue independently of the CRP. Judicially guidance. Regulatory authority operates outside the jurisdiction of NCLT NCLT. In the landmark cases, Embassy Property Develops Private Property versus State of Karnataka, Supreme Court. Role of liquidator in realization of foreign assets. During liquidation, the liquidator has a broader responsibility in relation to foreign assets. First, he will be responsible to identify and protect the overseas assets and investments. That was his first means priority or responsibility. Taking steps for realization or liquidation of foreign subsidiaries or assets subject to FEMA and host country laws. Closure of overseas bank accounts and reputation of balance, distribution of proceeds to non-resident shareholders in compliance with FEMA and RBI guidelines. Means that will be the role of the liquidator. In case company is in liquidation, so definitely he will have to sell the overseas assets. Okay, in compliance with the FEMA and the local laws of that country. Okay. The liquidator may engage foreign, legal, or professional advisor with approval of the adjudicating authority to assist in assets realization abroad. Practically, not possible for resolution professional to sometimes to sell which are outside of India. So it will be better if we will hire any legal and professional advisor so that we can sell the assets at the maximization of the value of as per the market rate or as per the maximum value. So it's good, and in that case liquidator will have to seek the approval or permission from the adjudicating authority. Adjudicating authority will give the permission to, and a resolution professional or liquidator can hire any foreign legal or professional advisor to assist to sell that assets. Okay, as per the business requirement. Requirement of RBI approvals during CRP and liquidation. Okay, first we have discussed role of RP in CRP, role of liquidator. Okay, and now coming to the requirement of RBI approval during CRP and liquidations. RBI approval or compliances may be required at multiple stages, including when we are transferring or issuing shares to non-resident person as a part of resolution plan. So then we will have to seek approval from RBI. Otherwise, we will not be able to means do such type of transactions. Conversion of foreign debt or ECB into equity, restructuring, write-off or extinguishment of foreign liabilities, sale of overseas investment or subsidiaries, repatriation of funds to non-resident creditor or shareholders. Such approvals are generally obtained post approval of the resolution plan, but compliance remains mandatory for its effective implementation. Means we need requirement of RBI approvals, whether we have already discussed whether company in a normal doing a normal business and company is not in CRP, although we have to comply the FEMA, no, in the same manner we will have to comply during CRP liquidation, and we will have to, as a RP or liquidator, we will have to take approval from RBI when we are dealing in foreign transactions, transfer issue of shares, converting foreign debt or ECB into equity, in sale of overseas investment subsidies. So in such type of transaction, we seek approval from RBI. Okay, and otherwise, as per resolution plan, we can also take a post approval, but compliance remains mandatory for its. If compliance will not be done, so then resolution plan will not be implemented because that resolution plan will be rejected by the NCLT or educating authority. So it is mandatory to do the compliance, although it can be also done after the post approval of the resolution plan. Now coming to the treatment of FEMA liabilities in resolution and liquidation. Monetary penalties imposed under FEMA for pre-CRP violations are treated as a claim against the corporate debtor. Monetary penalties imposed under FEMA for pre-CRP, okay, pre-CRP violations are treated as a claim against the corporate debtors. These claims must be addressed in the resolution plan or liquidation waterfall. Regulatory proceedings may continue against us while promoters or management notwithstanding resolution. So this thing we have already discussed. If there is a penalty, so then that will be considered a claim. But And in case of means that will be addressed in the resolution plan. Okay. Or in case of if company is in liquidation, so then as per section 53, as per waterfall mechanism, payment will be done. Regulatory proceedings, if against promoters or management, notwithstanding resolutions. Okay. So practically challenges, conflict between IBC timelines and RB approval process. This thing we have discussed. Incomplete records relating to foreign transactions. In that case, we have to face practically problem when we don't find the proper records. If proper record is there, then we are unable to track the foreign transactions. In that case, we have to means means approach to the RBI or ED. Okay. Violations, valuation complexity for overseas assets. Okay. Coordination with multiple regulators and foreign jurisdictions. These are the practical challenges because research valuer can do valuation of the assets which are in India, but valuation of overseas assets is little bit means difficult due to the complexity and coordination with multiple regulators and foreign jurisdiction. That is that comes in the practical challenges which we have to face practically. Conclusion: the IRP, RPI liquidator play a critical role in ensuring the insolvency proceeding involving foreign elements are conducted in a legal, compliant, and commercially viable manner. While insolvency professionals facilitate resolution and liquidation under IBC, they must operate with the FEMA regulatory framework, recognizing the independent authority of IRB and ED. Early identification of FEMA issues, transparent disclosure, proactive regulatory engagement are essential for successful insolvency outcomes involving cross-border elements. Means if we will identify well in advance means well in advance means if we will identify FEMA issues as early, so then what will happen? We can seek for approval and we can take appropriate step. If we will do all those things, then we will be able to complete our insolvency resolution process within time bound period. Otherwise, we will have to take extension from the adjudicating authority. We will take the approval. But it's good if if we can, if we may identify FEMA issues and transparent disclosures and proactive regulatory engagements. So then it will be good for successful for the purpose of the insolvency resolution process for the purpose of time frame. Now, process of reporting and regulation of FEMA violations. Okay. Now, compounding of contraventions under FEMA. Role of RBI and adjudicating authority. Whether RP can apply for compounding. Impact of penalties on insolvency state. So these things now we will cover. Process of reporting and regulation of FEMA violations during CIRP or liquidation. Historical non-compliance under FEMA often come to light. FEMA provides a structured mechanism for reporting, education, and regulation of such contraventions primarily through compounding or education. This thing we have already discussed. There is a prescribed and standard mechanism is already prescribed in the FEMA Act regarding reporting, regarding education, regarding regulation in case of any contravention in is there. So then we can go for compounding or education. Now, compounding of contravention under FEMA. Compounding is a mechanism under FEMA whereby a person who has committed a contravention can voluntarily admit the violation and seek settlement by payment of monetary amount, thereby avoiding prolonged adjudication. Governed Section 15 of FEMA and RBI compounding rules applicable to civil and technical contraventions. Objective is compliance and regulation, not punishment. Okay, compounding results in closure of proceeding for the specific contravention. Common compounding case during involves insolvency include delayed of or non-filing FDA ODA returns, ECB reporting violations, pricing guidelines deviations, procedural lapse in share transfers. Okay, these are the means if we have missed anything, if we have not done reporting part, if we have done any violation not intentionally, so then we can go for compounding. And what will be the role of RBI and adjudicating authority? primary authority for compounding of most FEMA contractions, because RBI and also don't want to means go for a prolonged cases. If compounding is also there, if means contravention is there, if time gap is there, so person can go and approach and go for compounding. And that is good for company, and that is also good for RBI, because RBI, if RBI will compound, if multiple cases are coming, so then it will be really difficult for the RBI to handle and manage. So that's why compounding is there. If company wants to go for compounding, that is good. Examine the nature, gravity, and period of default. Imposes a compounding amount based on RBI guidelines. Adopts a pragmatic and facilitative approach, including insolvency cases. Role of educating authority under FEMA. Deals with serious or known compoundable contraventions. Okay, this if there are serious cases, means civil cases and normal cases, then that can be handled through the compounding. But deals with serious or non-compoundable contraventions also there as per FEMA Act 1999, conducts education proceedings, has the power to impose penalties under Section 13 of FEMA. Proceedings may continue notwithstanding CRP. Compounding is discretionary. Education is enforcement oriented. Now, whether RP can apply for compounding. So as we have discussed, if yes, the resolution professional can apply for compounding subject to the following. RP acts as a authorized representative of the corporate debtor. Application is generally made after identification of contraventions. Prior approval CO is advisable as it involves cost to the state. Compounding during CRP helps clean up regulatory risk, improve implementability of resolution plans, enhance confidence of resolution applications. So that is good if resolution professional find key if there is a contravention, and if contravention is there, so then he can approach and he can go for compounding. That will be good, because if there is a statutory non-compliance is there, if there was a lag, and if you have regularized this thing, so that will be good for to attract the resolution applicants. Because if when resolution plan will be submitted, if we have not done compounding, then what will happen? We will have to do the impact of the compounding. So that's really create not a good image. If we have a funds and COC also approves this thing, so then definitely we must go for a compounding. If we will not go for compounding, what will happen? Due to the time gap, the compounding amount will increase, number one, and it may be three times of the duty evade. So that's why we must go for compounding in case if there is a violation found by the RB. And what will be impact of penalties on insolvency state? Monetary penalties imposed by FEMA under FEMA for pre-CRP. CRP violations are treated as a claims against the corporate debtor. Such penalties qualified as operational debt, means monetary penalties imposed. If there is a monetary penalties or imposed by the FEMA under FEMA, so the pre-CRP violations. Okay, pre-CRP company was not in CRP, so then these claims are treated will be treated as operational debt, because as you know government dues, okay, are also treated as operational debt. Statutory dues, for example, PFI, ESI, electricity, okay, and GST, income tax, these all claims are covered under the operational debts. In the same manner, if there is a means monetary penalty imposed by under FEMA, so that will also be covered or qualified as a operational debt. They must be included in the resolution plan, dealt with under the means liquidation waterfall. Okay, as we as per waterfall mechanism section 53, we have to means after liquidation or liquidating the assets of the corporate debtor, so we have to distribute the proceedings of the sale of the assets as per the waterfall mechanism section 53. what is judicial guidance? While in insolvency resolution may extinguish monetary claims if not included in the plan, regulatory power to investigate and educate violations survives. Penalty may not survive against the corporate debtor post resolution if duty duly settled or extinguished. Liability may continue against us while promoters of management. Okay. So now coming to the practical consideration for insolvency professional. Early identification of FEMA violation is critical. Evaluate whether compounding is commercially viable. Okay. Sometimes what is happening ki compounding is amount is too much high and we don't have funds. If we have a funds, if we will pay the compounding, so then we will not be able to survive the business because we need the funds. Uh, as companies already in the CRP process, that means companies facing the means crisis or there is a funds issue. So this thing also need to take care कि how much amount is pertaining to the compounding and coordinate timelines with RBI approval processes, disclose contingent liabilities transparently to COC and resolution applicants. If a resolution plan is being submitted by the resolution applicant, if there is a contingent liability, we need to disclose this is the contingent liability and this amount may be up to this amount. Means we need to recognize the container liability transmitted to COC and resolution applicant so that resolution plan can be approve and apply. Otherwise, what will happen if we will not show the container liability? If post resolution plan implement, if that will come, so that will be problem. So that's why it's need to means either we need to means take in the as a operational debt if that is pre-existing. Okay, if not identified or cleared as yet, then we will have to take as a contingent liability. We will have to be transparent to COC and resolution applicant. Conclusion: the FEMA framework provides an effective mechanism for regularization of foreign exchange violations through compounding and education. During insolvency proceedings, timely reporting and regulation of FEMA contraventions by the RP can significantly reduce regulatory uncertainty and facilitate smoother implementation of resolution plans. However, insolvency doesn't grant immunity from FEMA compliance and penalties remain relevant to the insolvency state unless lawfully settled. Now coming to the also another important segment, practically challenges and criticism in FEMA compliance during CRP. Delays due to regulatory approvals, lack of clarity on RP's authority, conflict between timelines under IBC and FEMA procedures, jurisdictional overlaps and uncertainty. Okay, delays due to regulatory approvals. When we are going to deal in foreign exchange transactions, RBI, as per FEMA, there is a standard timeline. Okay, due to this, sometimes it's take time. So then, due to this, what will happen? We will not be able to complete the resolution process within time period. So that's why we will have to seek for extension period. What now? Practical challenge and criticism in FEMA compliance during CRP. The interface between the insolvency and bankruptcy code and the FEMA present several practical difficulties during the CRP. While IBC mandates a strict time bound period, FEMA operates regulatory approval and compliance framework that is not designed around insolvency timelines. This mismatch because IBC is time framed, that is not a time framed, but time framed but not aligned with the IBC. Okay, so this mismatch sorry, has led to operational challenges and criticism from insolvency professional stakeholders. Delay due to regulatory approvals. Many resolution plans involve foreign investors, restructuring of ECB, conversion of foreign debt into equity, reputation of funds, all of which require approvals or post facto regulation from the RBI. These approval process under FEMA often extends beyond the CRP timelines, resulting in delays in implementation or otherwise viable resolution plans. Because IBC says that we will have to do the resolution insolvency process within 180 days. In 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 above cases, when we are dealing in foreign transactions, so then when we will go and seek approval from the RBI, so they will definitely take time as per the standard time as per as prescribed in the FEMA. But that timeline is not aligned with the insolvency resolution process. So in this case, what will happen? We will not be able to complete the resolution process within 180 days. When resolution process will not complete, that means the resolution plan will not be implemented. Resolution plan will be implemented when uh, we have taken or considered and that resolution plan is compliant with all the applicable laws. So it means there will be delay to implement the resolution plan. Okay, so means sometimes due to regulatory approvals, resolution plan or means resolution process take time. So that is the practical challenge for resolution professionals which we have to face. Now, another lack of clarity on RP's authority. The IBC code doesn't expressly define the extent of the RP's authority to represent the corporate debtor before RBI or the Director of Enforcement. This leads to uncertainty or whether the RP can independently apply for approvals, compounding or regulation, FEMA contraventions without explicit COC or NCLT directions. Practically, we have to report to COC. Okay, but independently, we have to take approval. We have to do the reporting with the COC. It's not clearly mentioned that without taking approval from COC or NCLT directions, can we means deal with RBI or ED. So that lack of clarity is there as per the IBC. Now, conflict between timelines under IBC and FEMA, this we have already discussed. IBC represents the strict outer timeline limit, 330 days, including extension for completion of CRP, whereas FEMA procedure approvals, education, or compounding don't follow any statutory timelines. The structural conflict often forces resolution applicants to incorporate conditions, precedent, or contingent clauses, diluting the objective of the time-bound resolution. Conflict between timelines under the IBC and FEMA. This thing we have already discussed because IBC time-bound period, FEMA is not a time-bound process, but there is standard timeline given, but that is not aligned with the IBC. Jurisdictional overlaps and uncertainty. Overlapping roles of NCLT, RBI and ED create uncertainty for stakeholders. While NCLT approves resolution plans, it cannot grant exemptions from FEMA compliance or direct regulatory authorities to expedite approvals. This dual oversight leads to fragmented decision making and means if NCLT have the right to means bypass the regulatory compliance, so then resolution plan can be implemented, but practically or means legally, NCLT don't have also the right to means take the decision and give the decision to bypass the any other applicable means prevailing laws. So that is the big challenge because we are reporting to the NCLT and we also have to take approval from RBI and we cannot bypass the reporting process and compliance part. So that's why it will take definitely time. So that is the overlapping roles of NCLT and RBI and ED create uncertainty for stakeholders. Now conclusion, the practical challenges in FEMA compliance during CRP highlighted the need for greater regulatory coordination and clarity, delays, authority ambiguities, and judicial overlaps often undermine the efficiency of the insolvency framework. A harmonized approach, clear guidelines or PRP's power, and fast track regulatory mechanism for insolvency related FEMA approvals. For example, if there is a provision in case if any company is in insolvency process, if they in that case if RP can fast track approval from RBI, okay, as per provision of the IBC, so that will be good because if there will be a provision, if company is in insolvency process, so then means approval if required, the time limit should be there. So it will be best good for IBC purpose. Means then the resolution professional will be able to complete their means insolvency process as a time bound period. Means fast track regulatory mechanism for insolvency related FEMA approvals could significantly reduce friction and enhance the effectiveness of cross border insolvency resolution, and that also will be helpful for in the case of cross border insolvency resolution process, because as of now, we are still means awaiting the notification, means provisions related to the cross border insolvency, also also group insolvency resolution process. Although we have a landmark judgments, because Videocon group went to the group insolvency because there was a internally um, inter company transactions, and it was so much. So that's why company Videocon group went to insolvency means process. Now, what is the impact of FEMA on CRP, resolution applicants, and value maximization? Impact of unresolved FEMA violations on resolution plans, impact of unresolved FEMA violations on resolution plans, due diligence concerns on resolution applicants, effect on valuation of foreign assets, risk allocation in resolution plans. Now, FEMA 1990 plays a critical role, and CRP, particularly where the corporate debtor has cross-border transactions, foreign assets, and NRI related transactions. Unresolved FEMA issues can materially affect resolution plans, investor confidence, and overall value management under the IBC. What is the impact? Pending or past FEMA contraventions such as non-compliance in FDA reporting, ECB breaches, and unauthorized overseas create create regulatory uncertainty. Resolution plan may be rendered conditionally upon post-approval compliance or compounding, delaying implementation and exposing resolution applicants to enforcement risk. Unlikely past statutory dues, FEMA penalties are not automatically extinguished unless expressly addressed. So that is the impact. Now, due diligence concerns of resolution applicants. Resolution applicants conduct extensive legal and regulatory due diligence to identify FEMA. Undisclosed or unresolved FEMA violation increase perceived risk, discourage foreign bidders, and may lead to conservative bids or withdrawal. Applicants often seek indemnities, remuneration, or price adjustment to mitigate potential liability arising from FEMA or non-compliance. For example, if we have taken as a contingent liability. Okay, what will happen? Because contingent liability means we are not sure how much penalty we will have to pay. Okay, that may be 10 crore, that may be 100 crore, because we are not sure. We can take as a contingent liability. Okay, but what will happen in that case? If I am submitting a resolution plan, so I will not be comfortable because I am not sure ki how much amount I will have to means take for that penalty, for that contingent liability. So that's why it's very challenging and not good from the resolution applicant point of view under resolution plan view. That's why, so we need to do due diligence as a resolution applicant so that we can identify and we can take decision and appropriate step, so that we can also means complete the resolution process in time frame period, unless and until we will not identify well in advance fairer FEMA related transactions and reporting, etc. So it will lead for means more time taking, and we will not be able to complete the CRP process in a time frame period. So that's why due diligence is very critical and important whenever any resolution applicant is going to submit the resolution plan. That is also very, very important for resolution applicant. Unless until, see, resolution professional is there, resolution professional will do their work, but resolution applicant is going to invest in the money in the company. So he will definitely go for due diligence, because sometimes if he will not go for due diligence, so all of a sudden he come to know कि he will have to pay such a huge amount and not viable this thing. So that's why due diligence is very, very critical and important from resolution applicant point of view. On that basis, resolution applicant submit the resolution plan, and in case if non-compliance is there, so that resolution applicant will not be so much comfortable, because he doesn't know how much actually amount will have to pay after implementing the resolution plan. Now, effect on valuation of foreign asset. Valuation overseas subsidies, joint venture of foreign bank account is directly impacted by FEMA compliances status. Restrictions on transfer, repatriation, or liquidation of foreign assets due to regulatory non-compliance can significantly reduce reasonable value. In some cases, unresolved FEMA issues may result in asset being discontinued or excluded from valuation altogether. So what will happen in that case? Ki our what is our objective? Value maximization. So that value will not be able to go for a value maximization of the assets if non-compliance is there, and if due to this, if registered value is not taken, that assets in the valuation, that will happen. Then value of the asset of the company of the debtor will definitely go down. So that will be negative impact on the means company side. Okay. Risk allocation resolution plans. Resolution plans increasingly allocate FEMA related risk through specific clauses such as a conditional implementation, escrow arrangement, indemnities, or post approval compliance obligations. While this enables plan approval with IBC timelines, excessive risk transfer may dilute value maximization and undermine the certainty and finality invoices under the code. Conclusion: FIMA compliance is no longer a peripheral issue but a central factor influencing CRP outcomes, effective identification and resolution of FEMA issues at an early stage. Effective identification and resolution of FEMA at an early stage enhances investors' confidence, improve assets valuation, and supports IBC objective of value maximization. A coordinated regulatory approach and clear guidance on treatment of FEMA violations would significantly strengthen the insolvency ecosystem. So this is also very important. Enhance investor confidence. If there is no violation of FEMA compliances, okay, if compliances are there, and if we have found if any FEMA issues in early stage, okay, so then what will happen? If we will find an early stage, so then we will be able to sort that issue well in advance. So then these things will enhance investors' confidence, improve assets valuation, and support IBC objective of value management. Also, I will include here time bound time period, because when we will solve these issues within time or early stage, so then with along with valuation, so we will be able to resolve that issue in less time. A coordinated regulatory approach and clear guidance on treatment of FEMA violations would significantly strengthen the insolvency ecosystem. So these are the practical challenges and criticism in FEMA compliance which we have to face during CRP and liquidation. Now, impact on resolution, applicants and stakeholders, FEMA perspective. Whether resolution applicants inherits FEMA liabilities, resolution applicants inherits FEMA liabilities, clean slate theory versus continuing regulatory violations, treatment of past FEMA contravention post resolution, RBA approval post resolution. So this segment is also important. Impact on resolution application stakeholders. FEMA compliance significantly affects resolution applicants and other stakeholders during and after the CRP. Understanding the regulatory implications ensure that resolution plans are viable, implementable, and legally sound. Okay, whether resolution applicants inherit FEMA liabilities when resolution applicant is submitting resolution plan, whether they have will have inherent FEMA liability. Resolution applicant don't automatically inherit FEMA liabilities of the corporate debtor if the plan is approved and the corporate debtor is taken over. However, continuing obligations such as ongoing violation or pending investigation remain enforceably by RBI or ED. Resolution plan often include indemnity clause to protect applicants from past contraventions. See here also now, when any resolution plan is submitted by the resolution applicant, he will not be liable for any liability which is not in the resolution plan which is was approved by COC and also by adjudicating authority above or other than if any claim, if any liability came, so then that resolution applicant will not be liable for this thing. But after resolution plan approval and when resolution plan is executed by the resolution applicant, so then going forward he will be liable for all the means compliance. But before resolution plan which is not approved, then that resolution applicant will not be liable. Practical application applicants conduct detailed due diligence to identify FEMA exposure and may require RPCOC assurance or treatment. Why he will not be liable? Due to this point. Clean slate theory versus continuing regulatory violations. Clean slate theory under IBC provides the post resolution, the corporate debtor is freed from pre-CIRP claims and debts included in the plan. Limitation regulatory violations under FEMA are not extinguished by resolution plan approval. Authorities retain the right to investigate, impose penalties, or seek compounding. Courts distinguish between financial claims and regulatory enforcements outside IBC previews. Arsal Mittal versus Tish Kumar Gupta, RPCOC cannot override statutory obligations. So that is the related judgment case. Now, treatment of past FEMA contraventions post resolution. Monetary penalties for pre-CRP. Violations can be treated as claim against the state if included in the resolution plan. Unresolved contraventions not addressed in the plan remain enforceable by RBI post resolution. The corporate debtor continues to comply with the reporting and rectification obligations while liability may lie with the erstwhile management in certain cases. RBI approval and post resolution. RBI approval may still be required for issue or transfer of share, repatriation of funds, restructuring, or conversion of foreign debt. These approvals are critical for plan implementation and may be conditions present in the resolution plan. Practically, resolution applicants must account for regulatory approvals when structuring bids and the RP must facilitate timely applications. Conclusion: while resolution applicants benefit from the IBC's clean slate principle regarding financial claim, FEMA liabilities and regulatory compliance continue independently. Early identification, disclosure, and structured risk allocation are essential to avoid post-resolution enforcement risk and ensure successful plan implementation. now, Now we'll discuss the landmark judgment and regulatory clarification on FEMA and IBC. Then we will also discuss the FAQs. Judicial approach on FEMA, compliance during insolvency. NCLT ancillate observation on foreign asset and approvals. Supreme Court principle on regulatory laws versus IBC. Key RBI circulars impacting insolvency cases. Judicial approach on FEMA compliance during insolvency. There is a landmark judgment case of Honorable Kolkata High Court in the case of Anup Singh versus Union of India. The Honorable Kolkata High Court held that the moratorium under IBC prevails over FEMA enforcement actions. Okay, that will prevails over FEMA enforcement actions. Okay, note compliance and reporting, including, okay, what prevails? FEMA enforcement action, including seizure, attachment of assets under FEMA during CRP and even after liquidation. This is because Section 14 says and Section 33(5) says of the IBC bar initiation or continuation of proceeding against the corporate debtor once insolvency proceeding begins. So these section means restrict any agency to take means any asset in their custody as per Section 14 and during CRP and in the liquidation. Okay, and also there is another Section 238 overriding clause of the IBC ensure that inconsistent laws like FEMA yield to the court's regime. Okay, now it's clearly mentioned that no enforcement action will be taken by the any agency, but compliance and statutory other things will be applicable during CRP and liquidation. Enforcement action will be restricted only. Outcome notice seizure. Notice seizure order under FEMA were quashed whether they conflicted with the IBC moratorium. However, actions against individual directors, officer may continue. If they have done anything wrong, the action can be taken by the FEMA under the FEMA, RBI or ED against the individual directors of or officers may continue, but they will not send the notice because as per Section 14, when moratorium starts, so no further legal action can be taken against the corporate debtors. No. NCLT and CLATE observations on foreign assets and approval. NCLT position, historical and relevant practices. Earlier NCLT benches, Assistant Director ED versus Rajkumar Rahlan applied Section 14 moratorium to FEMA proceedings, holding that FIRB or ED actions cannot be proceed against the corporate debtors assets during CRP. Okay, actions. Okay, now what are the key takeaways? Insolvency tribunals recognize that the enforcement actions, here in this case also, enforcement actions affecting the corporate debtor states, because if they see when any company is in CRP or liquidation, if any asset is being seized by the ED, so then we will not be able to means if I don't have asset and asset is seized by the ED, if during the CRP, then how will I survive the business? So then, or in case of liquidation, if we have to close the business, if company asset is in the custody of the any means with ED, so then how will we be able to sell the asset? I will not be able to sell the asset, then I will not be distribute this proceeding of the sale of the asset as per waterfall mechanism section 53. So that's why ED cannot held or seize any asset during CRPL liquidation. They can take means action or any proceeding against individual directors or any authorized person who have violated the any and done any violation as per FEMA Act. So the, individually action and proceeding investigation can be continued by the ED, but no asset seizure notification can be sent to the corporate debtor during CRP liquidation. If they have the asset in their custody, they will have to release the asset as per the IBC code. But means regulatory action cannot be taken by the ED or RBI during the insolvency or resolution process or liquidation. Now, as per Supreme Court principles on regulatory laws, IBC, while the Supreme Court has not yet delivered a direct famous specific Supreme Court judgment on FEMA versus IBC, a number of its overriding law jurisprudence is routinely applied in the FEMA IBC contest and was cited in the Anup Singh case. A primary IBC non-obstain clause, section 238 says the Supreme Court has repeatedly upheld that IBC overriding effect applies wherever there is an inconsistency, wherever there is an inconsistency between the code and the other statute. Okay, means that section gives the power to the IBC In case of any inconsistency is there with another as statute, then IBC code will override. Okay. The principle has been applied across diverse statutes, including the Electricity Act, Custom Act, Income Tax Act, and by extension is applied to FEMA, conflicts in insolvency contest. Now, reference Supreme Court jurisdiction. Pachimjal Vidyut PVVN versus Raman Ispat Private Limited case. IBC prevails over Electricity Act provisions. Okay, so in this case, it will clearly mention IBC will prevails override electricity provisions. In other case, Sundesh Bhatt, liquidator of ABG Shipyard versus CBIC. IBC prevails. That case was also very important and leading case. Means IBC prevails over Custom Act provisions. Okay, means in this case what happened ki goods was in the custody of the customs. So then when IBC and case will accept by the adjudicating authority, then custom will have to release if any goods, any material is in their custody because corporate debtor not paid the duty. Means IBC will override. Okay, the custom department can submit their claim. Okay, which will be covered as per a operational debt. Okay, and in case if claim is not submitted by the government authority in time frame period, so that will, for example, if resolution plan is approved by the COC and adjudicating authority, and after then if income tax department is coming and saying the assessment is there was a pending assessment and that was a recovery from the corporate debtor, so that this thing will not be entertained, because if plan is approved from the COC and adjudicating authority, and if government was supposed to submit their claim as per the IBC code timeline period, if not, till the time resolution plan is approved, claim can be means entertained. If resolution plan is approved, so then in any house circumstances that claim will not be entertained, because the logic behind is this: when resolution plan is already approved and resolution applicant already done each and everything. Okay, now if claim, who will bear the claim? Because resolution applicant also have the clean slate, because before resolution plan, okay, he will not be liable and bound other than the resolution plan. So that is the logic behind, and that is the objective of the IBC code. FEMA compliance obligation in insolvency setting through the lens of the IBC primacy. There is a land. Now we will discuss the jurisdictional restrictions FEMA versus other regulatory schemes. While the above authorities demonstrate IBC overriding effect, where assets and enforcement conflict with insolvency, recent decisions involving PMLA suggest that IBC don't override all regulatory enforcements and create view on PMLA, relevant and by analogy. That applicant tribunal held that IBC cannot override PMLA where the statute deals with the proceeds of crime. Okay. If there is a crime factor is there, then IBC will not override. IBC can override when there is an inconsistency with other statutes. If there is a crime is there, so then statute deals with the price proceeds of crime. Given the distinct panel purpose of PMLA, this suggests that regulatory laws with distinctive public policy objectives may in certain contests stand independently of IBCI moratorium, a provision that could become relevant in FEMA contests involving serious contravention enforcement actions and criminal remedies through not directly decided yet. Now, implications for FEMA compliance in insolvency: assets protected under moratorium. The company's assets can be seized, attached, or enforcement upon by FEMA authorities during CRP liquidation if such actions conflict with moratorium. As per section, the company's assets cannot be seized, attached, or enforced upon by FEMA authorities during CRP liquidation if such action conflicts with moratorium under Section 238. So this section we have already discussed. If moratorium starts, so assets cannot be seized. Regulatory enforcement against individuals proceeding for personal liability or officers or directors for past FEMA violations may still proceed even during moratorium, where the action does not affect the corporate debtor's estate directly. Because as a resolution professional, you need the corporate debtor's asset. Whether if you are in CRP process, your objective is to survive the business. Okay, if practically if survival is not possible, the company will go into the liquidation. But in both the cases, you need the corporate debtor assets. If corporate debtor assets will be in the custody of the any statutory authority, then you will not be able to means uh, survive the business if you are in the CRP. And if you are in the liquidation, then you will not be able to sell the asset. The purpose and objective of the IBC code will defeat in this situation. So that's why it's clearly mentioned in FEMA and also in case of PMLA. After means if a moratorium start and as per Section 238, company assets will not be seized, attached. Okay, but on personal level, investigation can be done. Okay, during moratorium and after moratorium against who was responsible for this act on personal liability of officer or directors. If found, so then appropriate action can be taken by as per the FEMA Act. But asset will not be taken by the agency. Now question comes, another is regulatory clarification by RBI FEMA context. Through no judicial regulatory activity indicates the RBI continues to flag compliances, breaches, overseas guarantees under FEMA, emphasizing corporate adherence even outside insolvency process. This underscores that regulatory breaches under FEMA remain substantive liabilities even if enforcement actions are posed during insolvency. Now, what are the key principles emerged here? Judicial form principles on FEMA IBC. Calcutta High Court, Anup Singh. IBC moratorium under Section 1433(5) overrides FEMA enforcement actions affecting corporate. Clearly mentioned, overrides FEMA enforcement actions affecting corporate actors. Okay. In here, if there is a compliance of and other compliance and reporting will not override. Okay, only enforcement actions will be override as per the IBC Act. NCLT moratorium applies to FEMA proceeding involving assets. RP liquidator can invoke the court's protections. Okay. Supreme Court, IBC Section 230 overriding effects applies where inconsistency exists whether with the other laws, and this principle is applied to FEMA conflicts. Okay, now NCLT on PMLA. Regulatory enforcement can in some areas operate independently from insolvency moratorium, contractual regulation, or of distinct legal purposes. What is the conclusion? The judicial approach to FEMA compliance in insolvency underscores a balancing act. IBC moratorium protects corporate assets from conflicting enforcement action under this is very important. Here we are again saying conflict enforcement action FEMA during insolvency. So IBC moratorium protects only if there is a conflict and enforcement action regarding insolvency. Section 238 overriding effect equips tribunals to harmonize competing statutory regimes in favor of unified insolvency process when inconsistency arises. Distinction remains where regulatory statutes serve distinct public policy purposes, suggesting that not all regulatory enforcement is swept away by insolvency law in every scenario. Okay. Now, landmark judicial pronouncements and regulatory clarifications involving the interplay between FEMA and the Insolvency Bankruptcy Code. See here, there is a case Anup Kumar Singh versus Union of India by Calcutta High Court. What was the fact? In the liquidation proceeding of Shri Ganesh Jewelry House India Private Limited, the enforcement director issued asset seizure notices under FEMA Section 37A even after CRP commenced and liquidation was ordered. Okay, means here in liquidation proceeding was there, ED issued asset seizure notification. The CRP was commenced and liquidation was ordered. Okay, now what was held here? IBC moratorium starts as per Section 14 and Section 33. Prohibits continuation or initiation of the any legal proceeding against the corporate debtors' assets once CRP or liquidation has commenced. Section 14 and Section 30 says prohibits. Okay, no further legal action can be taken. No legal proceedings and no case will be against the corporate debtors. If you have any claim, you can submit directly claim. Okay. Now, IBC. Okay, now, since IBC has an express overriding clause under Section 238, its moratorium provisional prevail over conflicting FEMA actions. FEMA proceedings or seizure orders issued against the corporate debtor during insolvency and liquidation were quashed. Proceedings may still be initiated against directors or officers personally liable, but not against the corporate entity. See, this thing we have already discussed in above cases. Proceedings may be still initiated against corporate debtor officers personally who were liable. So that was important. Okay, see, another was FEMA proceedings seizure issued against the corporate debtor during insolvency were not allowed. Okay, IBC has the overriding effect, and as per moratorium start, so then asset cannot be seized. So, this is means very good, and this is landmark judgment case. Now significance. This case is critical in the FEMA IBC contest as it extends IBC moratorium protections to bar statutory enforcement. Okay, IBC moratorium protects to bar statutory enforcement action, but investigation during moratorium, CRP, liquidation against persons, corporate debtors, officers who were liable can can be done against under this IBC or FEMA Act. Under FEMA, in reinforcing the primacy of the insolvency process over regulatory seizures of assets during CRP liquidation. So this case is really, really very important. Now there is another case, Ram Sarup Industries Limited versus Union of India. Through no directly a FEMA case, Ram Sarup Industries Limited is relied upon in Anup Kumar Singh was case illustrated Supreme Court approach to IBC overriding effect. The decision emphasized that the IBC non-obstant clause section 238 enables it to prevail over other statutes to the extent of inconsistency of the IBC scheme. It's only we have discussed as if section 238 says IBC have the overriding fact where inconsistent in other statutes. While involving other statute PMLA, the rationale has been applied by courts to similarly regulatory statutes including FEMA. Take away this case underpins judiciary reasoning that IBC overriding provisions subsumes inconsistent provision of pre-existing statutes as part of the coherent insolvency regime. There is another case, precedents affirming Section 238. Although not directly on FEMA, the Supreme Court has repeatedly upheld the overriding fact. There was a there were so many related cases. PVVNL versus Raman Ispat held that Section 238 allows IBC to prevail over conflicting provisions of the Electricity Act demonstrate that IBC scheme dominates where conflict exists with other sectoral laws. There was another case, Sundarash Bhatt Liquidator Custom clarified that IBC provision prevail over the Custom Act, interpreting Section 238. Okay, we have discussed this case. Innovative Industries Limited versus ICICI Bank Limited affirmed that non-obstant clause Section 238 and then Section 32A precedence allows IBC to take precedence over older enactments. Now, principal expression. Principal CIT versus Monet Ispat Energy Limited held that the IBC overriding provision approves inconsistent provision of the Income Tax Act. Although this case doesn't involve FEMA directly, they are frequently cited by courts, Calcutta High Court, to apply the overriding principle in FEMA IBC conflicts. Now, there was an NCLT enclave decision on FEMA, ED actions during insolvency. While the Supreme Court has not issued a direct FEMA IBC judgment, various tribunals and high courts decisions have shaped the understanding. Assistant Director ED Rajkumar Rahlan held that the moratorium under Section 14 of the IBC applies to proceeding under FEMA, such that the ED could not proceed against the corporate debtor while CRP was ongoing, reinforced that enforcement action that interfere with the insolvency state are barred. Note this NCLT decision is cited in later High Court rulings quashing FEMA actions during moratorium. DR FEMA can still be pursued against act of offense. This thing we have already discussed in above cases. Regulatory clarification. This is also very important by RBI or FEMA regime. While no judicial decisions, regulatory practices reinforce that FEMA compliance continues even during insolvency. Compliance. Okay, compliance will continue during insolvency. This we already accepted. Through its enforcement may be stayed by legal moratorium. FEMA contraventions can be compounded by RBI and such compounding application may be made by the corporator, often via RP, to regularize defaults even while CRP is going. However, where moratorium implies direct attachment of enforcement by authorities might be legally barred until the insolvency process conclude. Legal principle reflected in Anup Singh application of Section 14 oblique Section 33. That was very important. So that is very important clarity by the regulatory clarification by the RBI and FEMA regime. Okay, what are the key takeaways? If we will in shortcut, we will say there was case authority Anup Singh University Union of India IBC moratorium will override impact 238 or over FEMA enforcement actions during CRP liquidation. So this thing we have already discussed. This is in shortcut summary. There was another case, Ram Sarup. Section 238 allows IBC to override inconsistent statutory provisions. In case of Paschimil, PV Vinel versus Sundar Bhatt, Innovator, these are the three cases. Section 238 allows IBC to override. In these three cases, it clarified Section 238 will override in case of inconsistency in other laws. Legal principle IBC overriding effect applies across regulatory statutes. Case authority Assistant Director ED versus Rajkumar. Legal principle moratorium under IBC applies to FEMA enforcement actions. Now conclusion. While the Supreme Court has not yet delivered a FEMA specific jurisprudential directly on the IBC FEMA interplay, the overriding effect of IBC moratorium over FEMA enforcement actions has been affirmed by the tribunals. Calcutta High Court, the border jurisdiction of 238 of the IBC, these authorities underscore that enforcement action under FEMA affecting the insolvency states are generally barred. Enforcement actions, okay, see here. Enforcement actions are barred. RP liquidator can invoke IBC protections to prevent attachment of seizure. This thing we have also discussed. Okay, enforcement actions are barred, but if moratorium start, so then if any asset in the custody of the authority can be taken back and no agency can means attach the asset of the corporate debtors. Now we will FAQs. In shortcut, we will discuss some of the FAQs. FEMA proceeding under IBC 2. Can FEMA penalties be waived in CRP? We have already discussed yes. In RBI approval mandatory during CRP? We already discussed yes. Can ED RBI proceed during moratorium? Okay. See, enforcement action cannot, but investigation against corporate debtor or officers can be done. Who bears FEMA penalties post resolution? This thing we have already discussed, but through FAQ we will understand. Can FEMA penalties be waived in CRP? FEMA penalties cannot be unilaterally waived by RP or COC. FEMA is a civil regulatory statute, and penalties imposed for contraventions are enforceable by RB or ED. Compounding of contravention is available under FEMA Section 15 and may be applied by the corporate debtor through RP with COC approval even during CRP. Okay. So we have this thing we have already discussed. Judicial presence, this case we have already discussed, clarified that the moratorium under Section 14 bars enforcement action but does not nullify underlying liability. Okay. Compounding is done for the if there is any violation. Okay. So then compounding payments may be factored as an operational or contingent liability in the resolution plan. Okay. If there is a pre CRP, so then we will take as a operational claim. Okay, otherwise, if not clear, so then as a contingent liability, we will have to take in the resolution plan. So means can FEMA penalty be waived of in CRP? Cannot be waived, but compounding can be done. Okay, if company is in CRP process, it doesn't mean key company then wave of facility will be given as per the FEMA. No, they can go for compounding, but waiving is not means as per FEMA. If any company is also in means CRP during CRP process. Is RBI approval mandatory during CRP? Yes, in case involving foreign exchange transactions. We have already discussed in case of foreign exchange transactions are there, then we will have to mandatory taking approval will be taken from the RBI. Okay, RBI's approval is required before implementation of the resolution plan, but the RP may facilitate applications during CIRP. Delay in approval can affect the timelines for plan execution, often requiring conditional clause in the resolution plan. Now, another one is can ED or RBI proceed during moratorium? The moratorium under Section 14 of the IBC applies to suits, recovery actions, and the enforcement against the corporate debtors. RBI ED proceeding affecting the corporate debtors estate are generally stayed during CRP. Exceptions: regulatory investigation not targeting assets of the corporate directly. Proceeding against promoters or directors may continue. This thing we have already discussed. Reference this case, we have also discussed these cases. Who bears FEMA penalties post resolution? Monetary penalties for pre-CRP contraventions. Pre-CRP contraventions, if included in the resolution plan, they are treated as a claim against the corporate debtor and settled through the estate. If not addressed, they may remain enforceable by regulatory authorities. Debtors management may remain liable personally for violations. Resolution applicants generally negotiate a remedy clause to protect themselves from residual regulatory liability. Do resolution applicants inherent FEMA liabilities? Financial claim under FEMA included in the resolution plan are absorbed by the corporate debtor, but regulatory and procedural compliance obligations continue. Okay, under the clean slate principle, past financial obligation may be discharged through the plan, but unresolved regulatory contraventions remain enforceable. Applicants should include risk allocation clause in the resolution plan for FEMA compliances. Can RP file for compounding under FEMA? So yes, we have already discussed. RP cannot apply for waiver. RP definitely go for compounding. Yes, the RP as the authorized representative of the corporate debtor can apply to the RBI for compounding or contraventions. Compounding reduces enforcement risk and makes the corporate data estate more attractive to resolution applications. Penalties paid under compounding are treated as a claims in the CIP state. Treatment of ongoing FEMA interventions during CRP. Investigation may continue, but enforcement action against corporate debtors, as I said, this we have already discussed. RP is responsible for reporting contraventions. Okay, but enforcement action cannot be taken by the authorities. Impact of unresolved FEMA violations on resolution plan valuation. Unresolved valuation may lead to discounted valuation of foreign assets. Okay, delays in implementation and risk allocation clauses. Resolution applicants often perform enhanced due diligence on FDI, ECB, and ODA compliance to assist potential exposures. Okay. See, I will share this PPT. If you have any query and question, you can ask. Otherwise, we can conclude this session. If you don't have any question, then we can we conclude the session? Okay.
Yes, sir.
Okay. Okay. We are concluded. Okay. Bye.
Thank you very much, sir. The session was very wonderful and nice. Sir, we are requested to please share the PPT of the session.
Definitely, I will share the PPT. Definitely.
Thank you very much, sir. Please share the PPT as I
Sure.
mentioned. Thank you.
Sure.
Very informative, sir. Very detailed, actually.
Thank you. Thank you.
Thank you.